So, you filed a personal injury claim. You've done your part and probably think that you're on the right track to getting what you deserve. But what you don't see is that the other side's insurance company has already started building a case against you. Filing the paperwork wasn't the end of the fight, and in a lot of ways, it was just the opening bell. The choices you make next could be the difference between justice and walking away with nothing. A lot of people think that the process is simple from here on out. They figure, I'm the one who got hurt, so the system will take care of me. That's just not how it works. The second your claim lands on their desk, a team of adjusters, professionals whose only job is to pay you as little as possible, gets to work. Their goal is to protect their company's profits, not to help you. Hi, I'm Jim Curtis. I'm a personal injury lawyer here in Apollo Beach, Florida, and I help accident victims throughout the Tampa Bay region and across the state of Florida. For years, my team and I have helped hundreds of people just like you get through the mess that follows an injury. We've seen every trick in the book. Today, I'm going to show you exactly what happens behind the scenes and give you a clear, simple plan to protect yourself. So let's get started. Once your claim is filed, the insurance company starts its own investigation. But they're not looking for the truth. They're looking for excuses. Excuses to deny your claim or slash its value. They usually follow a three-part strategy, and it's incredibly effective. First, they'll try the recorded statement trap. You'll get a call within a few days, maybe even hours, from an insurance adjuster who sounds incredibly friendly and concerned. They'll say they just want to get your side of the story or clarify a few things. Then they'll ask you if you mind if they record the call. It seems harmless, right? Wrong. This is a trap. You should always politely say no. Why? Because adjusters are trained to ask tricky questions. They might ask, "How are you feeling today?" If you say I'm okay, even if you're just trying to be polite while sitting in a world of pain, they'll write in their file, "Claimant says they are okay." They'll ask you to describe the accident, hoping you mix up a tiny detail they can use to call you a liar later on. If you say something like, "The other car came out of nowhere," they'll twist it to mean you weren't paying attention. If you downplay your injuries because you don't want to complain, they'll use that as proof your injuries aren't that bad. The adjuster is not your friend. Their job is to save their company money, period. Second, they'll dig into your entire medical past. Next, you'll get a medical authorization form in the mail. It looks like a standard form they need to check on the injuries from your accident. But if you read the fine print, you'll see it often gives them permission to get every single medical record you've had since you were born. They aren't just looking at records for your crash, they're digging for dirt. Did you strain your back playing softball 10 years ago? They'll say your current back pain is just a pre-existing condition. Went to a chiropractor for a stiff neck once? They'll argue your whiplash has nothing to do with this accident. Their goal is to create a story that your pain is your own fault, not their client's. It's a massive invasion of privacy, and you should never sign a broad medical authorization form without a lawyer looking at it first. An attorney can limit the authorization to only the records that matter, keeping the rest of your history private. Third, they'll hit you with a fast lowball offer. This is their slickest move. They know you're in a tough spot. You might be out of work, medical bills are showing up, and the stress is piling up. So they'll dangle a quick check in front of you, maybe for a few $1,000s. They'll say it's to help you get back on your feet and move on. It's tempting, I get it, but taking that offer is one of the biggest mistakes you can make. That first offer is almost always a tiny fraction of what your claim is really worth. It comes before you're done with treatment, before you know if you'll need surgery down the road, and before you know how much work you'll miss. If you take that money, you sign away your rights to ever ask for more for this injury, even if you find out later you'll need lifelong medical care. They're banking on your short-term pain to cheat you out of the long-term compensation you actually deserve. Knowing their playbook is one thing, having your own is another. Here are 3 things you need to do right now to protect yourself and build a case they can't ignore. Step 1, document everything. From this moment on, think of yourself as the lead detective on your case. The strength of your claim comes down to the quality of your evidence, so you need to document everything. First, your health comes first. Get medical care and actually follow your doctor's advice. If you skip appointments or don't do your physical therapy, the insurance company will argue that you must not be that hurt. Keep a file with every doctor's visit, bill, and prescription receipt. But go deeper. Start a daily journal. Just a few notes a day. What's your pain level from 1 to 10? How are your injuries making your life harder? Can you no longer pick up your kids? Do you need help carrying your groceries? Did you have to miss a family event? These aren't just details. These are what we call pain and suffering, and they are a huge part of your claim's value. Finally, save all the evidence. Take pictures of your bruises and cuts as they heal. Keep the torn clothes you were wearing. Make sure you have the names and numbers of any witnesses. The more you document, the less room they have to argue. Step number 2, go on an information diet. Your next move is to take total control of what you say and who you say it to. Like we talked about, the adjuster is trained to use your words against you. The rule is simple. You don't have to talk to the other side's insurance company. When they call, you can just say, "I won't be giving a statement. Please direct any questions to my lawyer." If you haven't hired one yet, just say, "I'm not ready to discuss my claim right now." That's not admitting anything, it's protecting your rights. This goes for social media too. Insurance companies absolutely hire people to scroll through your Facebook and Instagram. That picture of you smiling at a birthday dinner could be used to argue that you're not really suffering. A post about taking a short walk could be used to question your injuries. The smartest thing to do is set all your profiles to private and stop posting anything about your accident or recovery until your case is over. And step number 3, know what your claim is really worth. That lowball offer works so well because most people have no clue what their claim is actually worth. It's not just about the bills you have today. A fair settlement has to cover 3 key areas. First, your economic damages. This is all of your medical bills, past and future. It includes physical therapy, potential surgeries, and prescriptions. It also covers all the money you lost from being out of work and even your ability to earn money in the future if you can't go back to your old job. Second, your non-economic damages. This is what's known as pain and suffering. It's compensation for the physical pain, the emotional trauma, the anxiety, and the ways that your life has been turned upside down. There's no simple calculator for this. We put a value on it by telling your story, using your journal and medical records as proof. Finally, in some situations, there may be punitive damages. These are meant to punish the person who hurt you for being incredibly reckless. Figuring all of this out is complicated and takes experience. It's why grabbing a quick check without knowing the full picture is so risky. This is a job for an experienced lawyer who can work with experts to calculate the true, full value of your claim. The time after you file an injury claim isn't for waiting around. It's an active game of strategy, and the insurance company is playing hard to win. They're hoping you're confused, stressed, and worried about money. They're counting on you to make a mistake, to give that recorded statement, sign that blank check medical release, or take that first lowball offer they throw at you. But now you know their playbook, and you have a counter playbook. You know you need to document everything, control the conversation, and understand what your claim is really worth. That knowledge gives you power. You don't have to do this alone. If you're injured and feeling the pressure from an insurance company, it's not too late to get help. Just give me a call, or you can visit my website at calljimthelawyer.com. We'll answer your questions and tell you exactly how we can step in. We'll take over all of the communication with the insurance companies so you can focus on the only thing that matters, getting better. Now that you know the lengths that the insurance company will go to just to save a few dollars on your claim and the steps that you can take to avoid this, be sure to check out this next video to learn 5 simple things you can do to maximize your personal injury settlement. See you there.